Hello there, and welcome to the weekly Asylum and Immigration Reform Update, where I share with you 5 recent stories of interest to asylum seekers and those who want to stay current on immigration news. This week, we're discussing long-term U.S. residents deported to Colombia after 35 years, leaving U.S.-born children behind. Trump administration admits mistake in wrongful deportation of Maryland man to El Salvador. Federal judge blocks attempt to end temporary protected status for 600,000 Venezuelans. Court halts Idaho's controversial state-level immigration enforcement law hours after signing. Analysis shows birthright citizenship restrictions could add $3,000 birth tax for American families. I'm Brian Manning, and I used to be an asylum officer with the government, but now, as an asylum lawyer, I help immigrants all over the country to secure their future in America through asylum. It's my pleasure to bring you asylum and immigration reform updates each week, right here on the Political Asylum Lawyers YouTube channel. Okay, let's get to the news. First up, after more than 3 decades of building a life in the U.S., a couple was abruptly removed to Colombia following a routine immigration check-in that unexpectedly resulted in their arrest and subsequent confinement in multiple detention facilities across several states. The parents, who sought refuge from violence in Colombia in 1989 and had maintained regular contact with immigration authorities since 2000, were denied the opportunity to settle their affairs or bid farewell to their family, including a recently born grandchild. Their legal representative revealed they had spent decades attempting to regularize their immigration status, but fell victim to unscrupulous practitioners in the 1990s, investing substantial sums in legal services that sometimes came from individuals who weren't qualified immigration attorneys. Despite their unblemished criminal record, tax compliance, religious community leadership through Bible studies and volunteer work during the pandemic, the couple exhausted all avenues for relief after numerous appeals. Their daughter emphasized that despite their deep love for America and financial sacrifices in pursuit of citizenship, her parents were ultimately let down by the immigration system and not afforded the dignity of putting their affairs in order prior to deportation. And next up, for update number 2. The Trump administration has acknowledged a serious mistake in deporting a Maryland resident to El Salvador despite a previous judicial finding that he faced legitimate persecution risks in his home country. The man was erroneously included on one of 3 deportation flights on March 15 during the controversial operation that primarily targeted Venezuelan nationals being sent to El Salvador under the seldom-used Alien Enemies Act. An immigration judge had previously ruled in 2019 that while the man was allegedly connected to MS-13 based on a confidential informant's claim, his fear of persecution or torture in El Salvador was credible, resulting in his release from custody. He had been residing peacefully in Maryland with his American citizen wife and child until his sudden arrest by ICE on March 12. Despite conceding the mistake, the Justice Department is asking a federal judge to reject attorney's petition seeking his return to the U.S., asserting the administration has no power to force El Salvador to return him. The deportation occurred amid a larger legal battle over President Trump's use of war powers to expedite deportations, which a federal judge has temporarily halted while court proceedings continue. All right. Time for our third immigration update. A federal judge has intervened to prevent the Trump administration's attempt to terminate temporary protected status, TPS, for 600,000 Venezuelans living legally in the U.S., which would have left 350,000 immediately vulnerable to deportation. U.S. District Judge Edward Chen in Northern California issued a court order blocking Homeland Security Secretary Kristi Noem's February order to end the program while legal challenges proceed. In his ruling, Judge Chen concluded that terminating TPS could harm hundreds of thousands of people, cost the economy billions of dollars, and injure public health and safety, while the government had failed to identify any substantive harm in maintaining the program. The Biden administration had originally designated Venezuela for TPS in March 2021 based on extraordinary and temporary conditions, and extended it through April 2025. Secretary Noem had attempted to defend ending the program by claiming it allowed inadmissible or illegal aliens to settle in the country, including alleged members of the Tren de Aragua gang, and argued that immigrants had become financial burdens on communities. Judge Chen dismissed these arguments, noting that Venezuela remains classified as a Level 4 do not travel country and that TPS beneficiaries typically have higher education levels and lower criminality rates than the general U.S. population. And moving right along, update number 4. A federal judge has swiftly intervened to block Idaho's controversial new immigration law just hours after Governor Brad Little signed it into law and the ACLU of Idaho filed a lawsuit challenging its constitutionality. The law, patterned after Texas's contentious 2023 policy, would allow law enforcement to record a person's documentation status if they're suspected of a crime, and creates the state crimes of illegal entry and illegal re-entry for individuals without proper immigration authorization. It also establishes criminal penalties for trafficking a dangerous illegal alien, targeting anyone who knowingly transports unauthorized immigrants with prior criminal convictions. The ACLU's lawsuit contends the law violates the U.S. Constitution in 3 ways. It infringes on the federal government's exclusive authority over immigration under the Supremacy Clause. It violates the Commerce Clause by regulating entry into Idaho, and it's impermissibly vague. While bill sponsors claimed the legislation targets immigrant criminals, ACLU attorneys highlighted that it affects anyone suspected of even minor infractions such as littering, shoplifting, or disturbing the peace, regardless of whether they are ever convicted of those minor crimes. And finally, our 5th immigration update for this week. A new analysis from the National Foundation for American Policy Projects that President Trump's executive order attempting to end birthright citizenship would create a birth tax of at least $3,000 per child born in the U.S. The costs include a $1,385 government filing fee for the application for certificate of citizenship and attorney fees ranging from $1,500 to $10,000. Parents would need to provide biometric data and appear in person at government offices, creating additional expenses. Margaret Stock, an immigration attorney who contributed to the analysis, points out the process would be more complicated than employment verification, requiring extensive documentation of parents' immigration status. The policy would fundamentally alter birth certificates from sufficient proof of citizenship to just one component in a complex federal verification system. Currently, judges in lawsuits joined by 22 states and Washington, D.C. have issued nationwide injunctions blocking the executive order, which critics argue contradicts constitutional protections. The Trump administration has petitioned the Supreme Court to intervene. And that wraps up this week's immigration news. If you want to win asylum in the United States, then you should call my office today. We help people all over the country, so doesn't matter where you are. Call us now to schedule an asylum strategy session so that we can help you secure your future in America through asylum. Again, I'm Brian Manning, and it's an honor to serve you in your immigration journey.